for participating. We are going to get started with the fall 2025 below market housing landlord information session. As I said a moment ago, I welcome questions, so you can shout them out if you unmute and remute. You could also put them in the chat. But first, let's get started with staff introductions. So I'd like to introduce my coworkers, Jonathan Irwin Frank from the City Attorney Office, and also Renee Ortega from the Housing Office. Renee and Jonathan, could you please introduce yourselves?
Hi, as Nicholas said, my name is Jonathan Irwin Frank. I'm a Deputy City Attorney with the City Attorney's Office. I see a few folks on here that I have met with and emailed with before, so good to see you again. And yes, I'm the Deputy City Attorney that advises on the below market housing program.
Hi, good morning. My name is Renee Ortega. I'm a Staff Assistant 3, and I work for the Housing Division.
My name is Nick. I am a Policy and Performance Analyst within the Housing Division. I work with Jonathan and Renee on a bunch of different issues, but my role today will be as the presenter representing compliance functions within below market housing. And we'll be talking about some of the common issues that come up in below market housing, but the key to success will also be your questions and feedback about materials that would be valuable to you in your roles as property managers. So with that, let's see if I can. All right. Before we even jump into the specifics of the program and the requirements that go with the program, Renee, if you could please post the links in this slide to the Teams chat. These are useful links. You'll see the first one is administrative guidelines. These are, like the link says, a written out explanation of the rules as they have been for below market housing since 2022. And they are developed in addition to the corresponding section of Santa Monica Municipal Code. So they do not replace municipal code, but they do provide additional implementation directives on it. The second link is a copy of our recertification. The second link is a copy of our recertification packet. The third link is to the website where we have maximum rent and income limits by year. So we're currently in year 2025. The updated income and rent limits will change again around April or May 2026. But you can see the 2025 limits if you follow the third link. And the fourth link is a general city website for property management and owner representatives such as yourselves for the AHPP program. Great. So let's go into below market housing and deed restrictions. I want to start by clarifying what the deed restriction program is. I use AHPP and deed restrictions interchangeably with BMH in this presentation. A deed restriction is typically 55 years long, although not in each individual case. The majority are 55 years from the date of recording. And a deed restriction is setting out a formula and rules and requirements on the property manager for how they are going to, which units are affordable on the property, what level of affordability exists within those units, the procedures and steps that need to occur to fill the affordable units. In some cases, actually in virtually all cases, annual reporting requirements. That goes into today's discussion about recertification, and also general kind of housekeeping tips about how to keep tenant households and your own records as property representatives, owner representatives, compliant with the corresponding parts of municipal code and administrative regulations. We do get questions from people about the difference between deed restrictions, rent control, and voucher programs. So I do want to jump into that right to start. A deed restriction is, like I said, a 55-year agreement. It will ultimately expire. It is between the owner and the city being the other signatory, but it can be enforced by additional parties. So the city can enforce it, the public can enforce it, a tenant can enforce it, a legal aid advocacy group can enforce it. Tenants United for Better Housing Opportunities, a tenant group, right, can enforce it. A landlord group can enforce it. If you are aware of another landlord who has a deed restriction they are not following, they can enforce it. But we'll come back to that, but that's a deed restriction. Rent control is a separate program, although there are some instances where rent control applies to deed restricted units. Rent control is a city ordinance implemented by its own team within the city, and that limits how much the rent can go up every year by a percentage. Now, deed restriction rents do go up year over year, but most deed restricted units are not subject to rent control. Some are, most are not. And if you are unsure, you should review your deed restriction, and it will specify whether or not rent control applies to the affordable units. In some cases, we've even seen buildings where some units that are affordable have rent control and others don't. So if that is unclear or confusing to you, please reach out to us. And then the third program here is voucher programs. Vouchers are federally funded, and tenants can and do get vouchers and then move into deed restricted units. So it is not uncommon to have some number of households. If you have a building that is 20 units and 10 of them are deed restricted, you may end up having some or all of the deed restricted units leased to voucher holders. We will come back to what that looks like when you need to recertify voucher holders or verify their income as part of the deed restriction process. But for this, what we're getting at is, please mute yourself if you're sneezing. For this, what we're getting at is the federal government sets the rules for voucher programs. We need to follow those federal rules to maintain our funding, but that is not exactly the same program as what we're talking about. The program we're talking about today is deed restricted units, and voucher program recipients and participants absolutely can and do lease deed restricted units, but they are two separate programs. If you have a specific question where you are a property manager, you have a tenant who uses a voucher subsidy, and your question is about, you're not sure whether your question is a voucher question or a deed restriction question, you can reach out to our staff and we will direct you to the corresponding team to address your question. So I'd like to start with an audience poll. If you, as audience members, could please type in the chat yes or no. Have you personally reviewed the deed restrictions that apply to the apartment buildings we are discussing today that you manage with deed restricted units? And Renee, if you could give them maybe 30 seconds to type yes or no, and let me know if you see a lot of yeses, a lot of nos, some of both. Just let me know what people type in the chat.
Hi, Nick. I see a lot of yeses.
Okay. Thank you. And thank you everyone for participating.
A couple no's.
Okay, if you have not reviewed yet, it's never too late, but the sooner the better, because the earlier you're aware of the requirements, the earlier you will have an idea of what it will take to, make sure everything is lined up and in compliance with the program. If you do not have a copy of your deed restriction yet, please reach out to housing staff and we can work with you to get you a copy. So before we even get into recertifications, which is the main point of today's information session, I did want to touch on some best practices for moving people in. The reason I'm bringing this up is because we do see, if you're not following some of these best practices for moving people in, and then a problem becomes apparent in the recertification, that can be to the detriment of the property manager. So let's just go through this for a moment. Most deed restrictions will have language about the following subjects. So most deed restrictions will have language that the landlord or the property manager must notify housing staff in writing of vacant units. At a minimum, the deed restriction will require that the property manager advertise available units to the public. It may be more specific and require that the landlord specifically take referrals off of the city administered below market housing waitlist at santamonicahousing.org. A lot of times there's a requirement that if there are two similarly qualified applicants, similar credit, able to verify they're able to pay the rent, no adverse landlord references, you would give preference to the person who lives or works in Santa Monica 25 or more hours a week. That's called the local preference. And you also are required to make reasonable efforts to fill units that are vacant within 60 days. Is housing staff personally standing next to you every single day, checking on all these things? No, these become relevant and apparent. I mean, they're relevant all the time, but we revisit these when something gets flagged for our attention. So if there's a question about whether a certain household should be in an affordable unit, given certain circumstances, we will go back and we will say, can we have a lease copy? Can we have a copy of the house's rental application? We're going to try to get a better understanding of how you gave the affordable unit to the household and whether and if the household qualified at the time they moved in. That is a very important and relevant part of this broader conversation.
And I just wanted to know, you may be getting to this shortly, but so the vast majority of deed restrictions do require use of that list, but I know that Nicholas has told lots of folks that if they happen to be one of the people who's not required to, that referral list is still an optional resource that you can use if you're one of the smaller numbers whose deed restriction does not require use of the city referral list.
Thank you, and yes. And the reason that I want to touch on what I want to touch on in your comment is that using the city list can reduce documentation burden on property managers. So if you use the city list and you're not required to, if there's a question later about whether John or Jane Doe applied for the wait list, that's very easy for us to check when it's our own wait list. If you go off the wait list and freelance and select John or Jane Doe, it's on you. It's your responsibility as the property manager to show you met those other requirements. It's your responsibility to demonstrate I went off the wait list and I told housing in writing the unit was vacant. Versus you use the wait list, you submit a referral request, meaning the unit's vacant. That's how you notify us it's vacant. It's in our records already. If you go off the wait list, you need to keep records showing you notified us the unit's vacant, you advertised the unit to the public as applicable by the deed restriction requirement, you certified the tenant's income. That actually applies to you. Even if you use the city waitlist, you still need to make sure that the number of people aligns with what was reported on the waitlist, that the household income falls within the correct income range, and then explain or document if and how the tenant met the local preference or other preference requirements as set out in the deed restriction requirements. So that more falls on us if you use the city waitlist, and more falls on you if you go off the waitlist under the authorization of your deed restriction. Do we have questions on that before we move on?
Yes. Hi, Nick. How are you? This is Mo from Samuel. Nick, question for the 50% affordability level on the waiting list. For example, I have only 2 bedrooms under that affordability levels. We always request list after list, and it's not a complaint, but I'm just wanting to understand when I am able to specifically advertise the 2-bedroom 50% to public, not through the waiting list.
Thank you for your question. And you are not the first or the only property manager to mention your experiences using the city waitlist. I want to clarify that I am not the most knowledgeable staff member about how the day-to-day process of matching people on the waitlist to available units occurs. I can talk about it at a high level, but I am not the most knowledgeable. So with that caveat, as a general matter, the city, if and when the property manager can demonstrate they are using the city waitlist, for example, let's say the deed restriction says you have to use the city waitlist, the property manager's doing so and has that track record of promptly notifying the city when the unit's vacant versus telling us a year after the fact, submitting a referral request that has relevant information about the unit that says the number of bedrooms, is basically is a complete referral request, has a photo of the inside of the unit or a comparable unit, has a photo of the outside of the building. It's complete. So you've done your part. We send you a list of people from the wait list to speak to, contact, email. You go through that list. You're marking down what happens. I reached out to person A on August 25th. They did not respond. I reached out to person B on August 26th. They came to the unit, but they were actually a 3-person household, and they told me they were a 1-person household when I got it off the wait list. So there was an inconsistency there. As long as you're maintaining your documentation and you've gone through the people we've given you multiple, like we've worked with you in good faith, then you may have the opportunity to contact us and request a marketing plan, and we'll review it with you and approve it if we can see that you've been doing the other steps along the way. On the other hand, on the flip side, if you haven't been notifying us, if you have a history of not notifying us in a timely manner of your available units, or going off the list without getting approval first when you are required to get approval, I mean, you're required to use the waitlist by your deed restriction. If that kind of freelancing's happening and you're not, then we're going to ask that you first go through the process and just document that the process as it was set up and as you're required to under the deed restriction has been attempted to the best of your ability and is not able to generate the right referrals for this vacant unit. And then we can get to a conversation about a marketing list. I mean, a marketing plan. The marketing plan would still require that you as the property manager give a preference to people who live or work 25 hours a week in Santa Monica, people who are getting evicted due to, eminent domain or something of that nature. So it would still have that requirement, but there would be more flexibility off the wait list, even for people whose deed restrictions require them to use the wait list.
And I know like we will frequently, when we're communicating with property owners here about these kinds of challenges. And I guess I just wanted to sort of reiterate and emphasize that the more diligent you are, both in requesting additional referrals and in appropriately documenting the status of every referral, the faster you're going to be able to get a marketing plan, if that is appropriate for your situation. And just a quick note on technical matters, because we will have people say, I wasn't able to access the list, or just various different technical things. And I just wanted to note, like, again, it's not Nicholas or I that is the staff person who deals with this most directly, but the housing division is very responsive, and it is your responsibility to send an email or call if you're having a technical difficulty with the wait list, and then make sure that you're going through the batches of referrals. And again, if you're doing that to make sure that there is not a delay, then if it is in fact true that the market conditions are such that it's appropriate to have a marketing plan, you're going to get to that point more quickly than if you let 3 weeks go by because of a technical difficulty without reaching out to housing division staff.
Thank you, guys.
If and when people are encountering issues with the waitlist portal, it is also helpful for you to tell us whether you're using your phone or a computer and what model of phone or computer, and we forward that information to our software developer, and it helps them troubleshoot the issue as well. Okay. The next point is quite simply if and when you are leasing a unit that is deed restricted, you must tell the tenants in writing they are moving into a deed restricted unit. And the most effective way to do that is you need to sign an affordable housing lease addendum with them. We have a free template available on our website. I can point that out to you further through this presentation, but every single tenant who moves into a deed restricted affordable unit should be informed in writing, and you as the landlord need to maintain a copy of that written notification that the tenant signs for the length of the tenancy at a minimum. That's for your own record keeping to show that you have complied with the terms of the deed restriction. Audience poll, if you could go in the chat and type yes or no, were you aware of some of these deed restriction requirements and best practices in the last 2 slides, things that you may be required to tell us about a vacant unit? You may be required to take referrals off the wait list. So if you could go ahead and put yes or no in the chat, and Renee, if you could tell me in maybe 20 or 30 seconds, if you see a lot of yeses, nos, some of both, just let me know what people are typing, please.
I have about 6 yeses, Nick. No nos.
Thank you, Renee. I want to cover a couple additional best practices for leasing up tenants in affordable units. Leases need to list all household members, including minors. It needs to list the minor's name. Is the minor financially responsible if the adult does not pay the rent? No. But the lease needs to list each household member's name so that when a housing staff member looks at the lease, we're able to figure out how many people live in that unit. And we are able to identify who actually should be living in that unit and if there's any unauthorized changes in household composition, because the vast majority of leases do not allow, or almost none of the leases should allow subletting. None of them should, there should be, we'll get to some of the legal considerations here, but people in deed restricted affordable units as a general matter should not have household changes that are occurring without the landlord's written approval before the change occurs. So they shouldn't be inviting additional people into the household, swapping people out, et cetera, until if and when the landlord says, I give the go ahead, and the landlord needs to review that new person's income and assets and see how that works. Now, if you find yourself in a situation like that where the tenant's asking to swap someone out or they're asking to add a household member, please contact us, housing staff. We'll walk you through the process, because the bottom line is our goal is we understand that things can happen for households, but at the same time, we want to reward people who get into an affordable unit through applying on the wait list. And we don't want to be in a situation where, for example, John Doe's the original tenant holder, John Doe moves out. Now it's Jane Doe, and no one knows how Jane Doe got there, and she's not even on the lease. That can be very troublesome and hard to troubleshoot. So please make sure the lease lists all household members, and the lease must also prohibit unauthorized subletting and on household changes that do not have the landlord's consent beforehand. Okay. This is just a tiny sample of what a typical deed restriction looks like. And what you'll see is that the first section of the deed restriction, which is not visible on this slide, is about recital. So it's going to say this deed restriction is about 123 Main Street. It's between developer ABC and the city of Santa Monica. Right after that, in most cases, you're going to see this section. And this section is basically a declaration of how many affordable units are at the building and what affordability level the units are set at. So if you are a landlord or a property manager and you are not sure how many units are supposed to be affordable or what income level they are, it's the second section of the deed restriction, typically right after the recitals, that will tell you the total number and the affordability level of each unit. And some deed restrictions will even say Unit A is 50% affordable, 50% area median income. Unit B is 100% area median income affordable. It'll actually assign the affordability level to this specific unit. So with that, we're going to move on to calculating maximum incomes and rents, since that is something all of you need to do accurately for your compliance and annual reporting purposes. If we go back a few slides to the key links, the screenshot was from link 3, AHPP maximum income and rent limits. So this is the page that pops up, and we are looking at these 3 cells in the middle of the page. Now, which of these 3 to use depends on how old the deed restriction is. If you are not sure which chart to use, you can email us or contact housing staff, and we will get you pointed in the right direction and tell you use the first, second, or third chart along with the utility allowances at the bottom. This is what those charts look like. Here's an example. You'll see that if you click on any one of these 3 links in the cells, you're going to get 2 charts on the table that pops up afterwards. So the first chart is about income. The second one is about rent. And you have to navigate these charts to figure out and correctly calculate the maximum income and rent. Now, this is very important for your compliance obligations, because if you do not calculate this information correctly for your tenants, you may have over income tenants living in your units. You may incorrectly tell a tenant to vacate when they're not actually over income. You may be charging more than the deed restriction allows. So if you are not sure how to correctly calculate these numbers, please reach out to us proactively. But that's why we're reviewing this in this info session as well. So 2 charts. In this example, the deed restriction back here said you have 1 apartment at 120% affordability level. So when we look at the income chart, we're looking under the column for 120%. Now, then we have to figure out how many people live in that unit. So it's a 1 apartment unit. It doesn't say how many bedrooms on that particular deed restriction. Some of the deed restrictions do list it out by bedrooms. So that is up to the property manager. The property manager needs to keep track of how many bedrooms are in each unit. And then the household size at the time of application as well, because that's what you need to correctly calculate the maximum income for move-in and the maximum rent each year. Before I proceed, do we have any questions from the audience? Okay. I want to just focus on one more aspect of calculating maximum income. The numbers on the chart show the maximum allowable income for a new household that moves into the deed restricted affordable unit this year. For example, if you have a deed restricted affordable unit that the deed restriction sets at 120% affordability level, you're using the right-hand column. And let's say that the person who applies for the unit, it's a 1-bedroom unit, and the person who applies is a 2-person household. You're going to use row 2. Oops. You're going to use row 2, go over to the 120% column, and you can see that as a new tenant, the household may earn up to $145,400 and qualify for the unit. If they earn $150,000 and you've gone through the work, you've looked at their application, and they actually earn $150,000, you are required to say, I'm very sorry, you earn more than the maximum income. You should record that information on the waitlist portal if they came off the waitlist. And then you do not lease to them because they're over income. This translates a bit differently for continuing tenants. Presuming that you can demonstrate with your paperwork record and your record keeping that you admitted a household that was properly qualified and met the deed restriction requirements. It was not only income qualified, the household also, for example, is not the property owner. In 99% of cases, the property owner cannot live in the deed restricted unit. The property manager, in 95, 98% of cases, cannot live in the deed restricted unit. The owner's children, their family members, cannot live in the deed restricted affordable unit. So you meet these eligibility requirements, not only income, but including income, when the household moved in. Now, coming up for the recertification, the maximum allowable income goes up by 1.4. For a 2-person household, at move-in in 2025, they could be earning up to $145,400. But let's say they moved in 2024. So this is their first recertification. That means that this year, presuming you did it correctly when you moved them in, they can earn up to $203,560, 1.4 times more. I want to just harp on this just a bit so that you understand how to calculate the maximum allowable income for new tenants or continuing tenants as you put it into your recertification documents. Before I proceed, do we have any questions? Okay. This is what I'm talking about in terms of, this is an excerpt from the recertification packet, which we will review in more detail in the second half of this presentation and information session. But there are multiple fields in the packet that are marked very clearly highlighted for the property manager to complete. Please do not have tenants complete these fields. The tenant will not know how to complete these fields in most cases and is not expected to know how to. The tenant is expected to know that they live in a deed restricted unit. The tenant is expected to provide complete and accurate recertification information within a reasonable amount of time. But the property manager is responsible for completing the pages and signature lines that are clearly marked as property manager. So with that, there are fields like affordability level and maximum allowable rent where you will need to use this chart to come up with the correct numbers. So since we're on that subject, I'm going to explain the relationships that exist between property management, housing staff, and tenants. Your property management. So your role to housing staff is you would maintain compliance proactively. If you notice something's not right or you catch a mistake, we would rather hear about it from you at that time versus find out about it during an audit or because the tenant complains or something bad happens. To tenants, your role is to inform them and give them correct, accurate information about moving into a deed restricted affordable unit, the maximum rent, the maximum allowable income, and then also enforcing relevant city regulations on the tenants. For example, the city home sharing ordinance does not allow Airbnb or verbo activity in any unit in the city, whether or not it's deed restricted, unless the tenant has obtained a city license for home sharing. So if you become aware that something inappropriate is going on in the unit regarding home sharing, unauthorized subletting, it is your responsibility to nip that in the bud and act accordingly. We are here to be a resource. We cannot represent you. We do not provide legal advice. We are not lawyers, but you can reach out to us as a resource for information and troubleshooting around cases like that should they occur. Tenants' role is they obviously they owe you rent every month. They need to participate in the annual recertification process. They need to provide you complete, accurate, and timely information. Your role is to communicate with them proactively and give them concrete information about what they need to provide. So if the tenant has a question, do I need to provide this or that? You need to be able to explain what they do and don't need to provide to us. For example, they do not need to provide retirement account statements unless and until they are receiving a withdrawal or a monthly payout from a retirement account, in which case they do need to provide us a statement. Other than that, we don't need to see those retirement accounts. We're not looking at those. So the property manager's role with the tenant is to communicate the program requirements, put in writing things that you need from the tenant to have complete and accurate, timely annual reporting information, and so on. Tenants also contact housing staff directly. They might bring us a copy of a notice the landlord sent them about a rent increase. They might say, I have an issue where the unit across from me is doing Airbnb. Can you look up this unit? What's going on with it? And that's how, in some cases, how we find out that things have gone sideways with a particular unit in a building or in more than one, right? So this is to show you that there are interactions between all of us. The City of Santa Monica housing staff also will do audits of the annual recertification material, reviewed and follow up with questions as well. And it's the properties management's role to do their due diligence and make sure that they're confident with the material they're signing off on, and it doesn't have numerous and obvious inconsistencies in how they're looking at tenant income, assets, and household composition, among other things. With that, I'm actually going to yield over to Jonathan for a moment. I wanted to see if, Jonathan, you could touch on some of these related city municipal codes and ordinances that pertain to below market housing and our deed restricted units.
Sure. So starting with the tenant anti-harassment ordinance, this applies to deed restricted units just like it does to any residential rental unit in the city of Santa Monica. And that includes a broad range of tenant protections. The thrust of it is that it creates substantial liability for bad faith conduct, including but not limited to, bad faith use of fraud, intimidation, or coercion to get a tenant out of a unit. That is closely related to number 2 there, which is the just cause for eviction requirements. And so any tenant in a multifamily property, 2 or more units, is going to be protected by just cause for eviction requirements. That includes tenants in deed restricted properties. So we do understand that this can create challenges. For example, where there is a tenant who does not income qualify or doesn't meet the occupancy standards, they cannot just be told that they have to leave. Of course, you have to follow the normal noticing procedures pursuant to California state law. There also has to be a just cause for eviction. And so this is another reason why it's extremely important to sign that affordable housing lease addendum, because you need to be able to show that that tenant being over income or not qualifying or refusing to provide documents is a violation of their lease, in order to be able to promptly and effectively evict them if they should not be in that unit. And as some of you know, if that is not possible, it's not the case that, oh well. In fact, the housing division will enforce that, and they will, refer cases to our office, and we will have to come up with other kinds of solutions in order to ensure that there's appropriate compensation for non-qualified tenants being in units where, because of the eviction protections, and generally this is going to be in a case where it's not the fault of the tenant. So if the tenant was not at all informed that they're in a deed restricted unit and they didn't sign a lease addendum, then there may not be just cause to evict them, but that doesn't mean that the property owner is not then in a situation where there's an ongoing violation of their deed restriction with the liability that attaches to that. One other quick note I wanted to say about that is, of course, we feel it's very important for fairness, as well as for this, what I was just talking about, that all tenants sign an affordable housing deed restriction, an affordable housing lease addendum. But I did want to note that there may be situations where someone is not qualified for a unit, or is doing something that causes a violation of the deed restriction or otherwise violates city law, such as subleasing or Airbnb-ing an affordable unit without that being a licensed home share. And so it may be the case that even if the tenant did not sign a lease addendum as they should have, or I guess the landlord didn't properly present and require a lease addendum as they should have, you may nonetheless be able to proceed with evicting a tenant if there is a lease violation for not complying with city law, or for subleasing in violation of the lease as it is. And just to kind of clarify, even the Santa Monica City Attorney's Office, we represent the city, but we are not allowed to provide legal advice to individual landlords. So we can try to provide information about how the law works, but sometimes we'll get questions like, what specific language should I say in my eviction notice? We can't answer that. You would need to consult with your own attorney in order to obtain that kind of legal advice. But we can try to provide information and clarification regarding what the law requires. So number 3, the home sharing ordinance. Nicholas has touched on this, but short and medium term rentals in Santa Monica are strictly regulated. Generally speaking, the only kind of short term rental of 30 days or fewer that is permitted is what's called home sharing. A few things to note about that: home sharing requires both a business license and a permit that are obtained through an administrative process with the city. And generally speaking, that's going to be a person living in their unit who's having guests there at the same time that they are still in the unit. So not your typical Airbnb of an empty place, but they're actually in the unit at the same time as the guest. And that program is kind of designed for folks where that will be a way for them to be able to better afford where they're living by taking on people who will be there at the same time that they are. And then residential leasing requirements, that is, we sometimes call it the medium-term rental ordinance. I think that's sort of easier to, a little bit more intuitive. But what that law does is generally it requires any rental in Santa Monica to be for a minimum term of 1 year to a natural person who's going to live there as their full-time residents. And so, you can't have a 6-month lease, generally speaking, and you can't Airbnb for 31 days because, again, it has to be a natural person household renting for a term of 1 year. And generally, it has to also be not furnished. Again, the idea being that these residential rental units are for, permanent homes for people that need them. And so, I've been speaking generally about these, but again, if you have specific questions, we can try to provide information, and certainly you can consult with an attorney for legal advice. The sort of upshot, and I think Nicholas has alluded to this, is that you're almost never going to be in a situation where an Airbnb or a HomeAway or Verbo or that kind of thing is lawful in a deed restricted unit, and that may be both a violation of these ordinances and the applicable deed restriction in the vast majority of cases. So that's something to be on the lookout for, to let us know about right away, and to appropriately enforce.
Residential leasing requirements also apply to people who live infrequently or part-time in Santa Monica, but who are living somewhere else for a significant chunk of the year.
Right. And the other thing, a property owner is actually required under the terms of that ordinance to collect certain documentation showing that the unit is the person's primary residence.
Thank you. So Jonathan's touched on some really important points about compliance, and I'd like to tie that in with a few of my observations as well. The first is that from the perspective of housing staff, if a tenant violates a deed restriction requirement, then the landlord either knew or should have known and didn't do anything. Now the landlord is putting themselves at risk, because housing staff will view the landlord as responsible for enabling or facilitating or permitting wrongful activity in the deed restricted affordable unit. Tenants have and continue to come to our public counter and report certain situations and types of behavior to us. So I want to review some of those because they are real cases with real people, and I just want to address it in a transparent way with you so you understand what we're hearing on our side, so that you can act proactively. You were proactive and joined us for this information session. I just want to kind of give you that opportunity. So we have had people who come to us and say they have been living in a deed restricted unit X number of years, and they never knew until this week or this month that the unit was deed restricted. And if we ask the landlord, can we have a copy of the lease? The lease makes no mention of a deed restriction. And the tenant, that one or more tenants, maybe even multiple tenants, are putting in writing they've never been informed. And so that starts to establish a pattern or a practice where the landlord was not telling anybody that these units were deed restricted affordable units. The tenants are saying, why am I being asked now to provide documentation? No one ever told me that I couldn't make more than X amount of money to live in this unit. I actually do make X amount of money. I make too much to live in this unit, but no one told me. So again, this comes back to that idea of maintaining really careful documentation of what you're telling tenants in writing, and communicating to them the program expectations from the get-go, so that this does not become an issue down the road. They also come in and they'll ask us, they'll say, my landlord came to me on a Friday and told me I have to provide X number of documents by Monday or Tuesday. So our recommendation to landlords is, please give the tenants 10 to 14 days to provide documents. If they have not done so, please follow up in writing. Tell them, I've received X, I haven't received Y. We gave you 2 weeks. You are violating the affordable housing lease addendum that committed you to providing complete and accurate reporting information under the administrative guidelines for this program.
I did want to add there, because we have had cases come up where there are demands for documents, sometimes in a way that makes tenants worried that something is happening or they're going to be evicted, when they have no affordable housing lease addendum and they have no contractual obligation to provide those documents. That is obviously not a situation that you want to be in. It's similar to what we were talking about before. But the fact that you're trying to comply with the obligations of the deed restriction does not negate the obligation to comply with the tenant harassment ordinance, which is to say you can't be threatening or intimidating. And frankly, if there's not an appropriate contractual obligation, you may be in a situation where you can't require a tenant to provide those documentation, those documents. Again, that doesn't mean that you don't have to comply with the deed restriction or then work with the city to come up with an appropriate remedy. If you're in that situation, again, ideally we want to avoid that and have a clear affordable housing lease addendum for every tenant. And you're trying to figure out how to proceed, that may be something where you want to reach out to us. Again, we can't provide legal advice, but if you're navigating, making sure you're complying with the tenant harassment ordinance, but also trying to come into compliance, we want to work with you on that. What we don't want to happen, which has happened before, is sort of aggressively demanding things from tenants who didn't formally know they were in a deed restricted unit, don't have a lease addendum, and then are going to come to us on the other side and say, what the heck is happening? I'm being harassed. So more communication is better in that type of situation. We will certainly consider that in figuring out how to appropriately resolve cases where there hasn't been compliance.
Correct. Going off of that, if you are a landlord and a tenant is refusing to provide recertification information, but they have signed the affordable housing lease addendum, they moved in knowing that they are moving into a deed restricted affordable unit, you giving them written notice that they need to provide certain documents in general would not be an example of tenant harassment, which I bring up because I have seen tenants accuse landlords and or other parties of harassing behavior because the landlord said, please give me the complete documentation in writing. So unless you're saying, hey, unless you're saying it in a manner or making a threat, simply telling the tenant you're in a deed restricted unit, here's where you sign knowing you're in a deed restricted unit, we've given you X amount of time so far and you still haven't provided certain documents, please do so. That is, again, I'm not the lawyer, I'm not going to make that call, but I just want you to know we do see tenants who will throw that around, the anti-harassment ordinance, but the cases that have been resolved, right? If you look up Santa Monica tenant harassment ordinance, the things that are occurring are landlords making threats of tenants. It's not the landlord saying, please complete your recertification by the specified deadline.
Correct. And we expect prompt enforcement of affordable housing lease addendum and of the deed restrictions themselves, which if someone is, if you cannot determine their qualification and they're refusing to provide documents and they do have a lease addendum, that means going through the appropriate notice and eviction process for those people who can and should be evicted for not complying with their lease addendum and which effectively means not complying with the deed restriction.
Tenants have the right to review a copy of the deed restriction, and we recommend giving the tenant a copy of the deed restriction when they move in, so that we are all on the same page about what is required under the terms of the deed restriction. And then in terms of landlord and owner responsibilities, you also, like I mentioned earlier, should have a copy of the deed restriction, and you need to know which units are deed restricted, which units are at what level of affordability, how many bedrooms are in each of your deed restricted affordable units, the household composition living in those units, the income of those households at a minimum at the time they moved in with supporting documentation. You can't just write down on a form saying, I promise that so-and-so moved in with an annual income of $20,000. It actually has to be backed up by the documents we're talking about. So asset statements, income statements, things that where 1 + 1 = 2. We may request copies of things like proof of rent payment. How is so-and-so paying their rent? You certified them as earning $0 of income last year. You also certified that the rent is $2,500 every single month. So if they are up to date on their income, where is that rent payment money coming from? We may ask for something like that. We may ask for copies of any notices served, a notice of abandonment, for example, if the tenant is not living in the unit, and also copies of the tenant's rental application. Okay. Who has legal standing to enforce deed restriction requirements? I have touched on this, but basically any interested party has the ability to initiate action. So if, as a property manager, my suggestion to you is to be proactive, because any of the people listed here can flag issues and have legal standing to enforce a deed restriction that is not being followed. So cases where the landlord's using a deed restricted unit as their personal office space, where an inappropriate person has been living in a deed restricted unit, such as the owner, the property manager, the property management company staff, when that's not allowed by the deed restriction. Those are all things where if someone is aware of it and chooses to follow up, the landlord could find themselves in an uncomfortable situation with legal risk. To go into this just a little bit further, so we've had waitlist applicants come to our office and email us saying, I have a tip, here's the tip, will you give me the top position on the waitlist? Which we won't, but people have tried that. We have unauthorized subletters who will walk into our office and say, hi, I've been actually living at unit 123 for several years. I know that John or Jane Doe is the person on the lease, but I've actually been living there. John and Jane Doe actually live in another state. So they may come and play whistleblower and try to figure out how to resolve their situation with the landlord. We had people come in, like Jonathan mentioned, who say, I've been living in this unit for X number of years, and until this month, I never knew we were in a deed restricted unit, and now the landlord's making statements about what's going to happen with my tenancy because they've given me a short window of time. They're telling me that I need to provide all these documents, and I am caught in this whirlwind. What do I do? We have neighbors who are coming to us who say, the other unit down the hallway is at Airbnb. I'm getting knocking on my door at a weird hour of the night because tourists are coming in from the airport and can't find the key. And I'm tired of this, so I'm reporting it to you. We do get that. We get people who, we get banks and lenders who are interested in acquiring a property with deed restricted affordable units who want a compliance letter. So at that point, we need to look at compliance and the history of the property to see if we can write that letter, or what needs to happen so we can write the letter for the lender. So all of this is to say that proactive compliance is much more sustainable and gentle on the company's bottom line and reputation than allowing things to grow and kind of not attending to things proactively. Proactive compliance and enforcement will be more effective for you.
And the city attorney's office does bring lawsuits to enforce affordable housing deed restrictions where necessary. We do try to work with property owners to reach a fair and appropriate resolution, depending on the particular facts of the particular case. But we are not, we do actively enforce violations of deed restrictions, including through filing lawsuits. So just be aware of that.
And we don't do confidential settlements, to my understanding.
That is correct. As a matter of policy, we require a stipulated judgment, and that often what can happen is that there is effectively a settlement reached, and then a complaint, like a lawsuit, could be filed at the same time as a settlement. And that will include modifications or extensions of the deed restriction, in addition to monetary payment and what other remedies are agreed upon. So it's non-confidential. It is filed in court, but if we have worked productively with you or your attorneys, that lawsuit may be filed at the same time as a stipulated judgment settling the case.
Thank you. We've touched on all of these except for the first one so far. So for 2 and 3 bedroom units, deed restrictions have, at most deed restrictions have occupancy minimums, meaning that it is not acceptable to refer a 1-person household to a 3-bedroom unit. A 2-bedroom unit needs at least 2 occupants, a 3-bedroom unit needs at least 3 occupants, and it is the landlord's responsibility to screen applicants accordingly, refer them into units that are appropriately sized to the household size. If you move a household that's a 1-person household into a 2 or 3-bedroom unit, or a 2-person household into a 3-bedroom unit, absent a strong case otherwise, such as, I mean, there are cases that I can think of that would justify it, but absent a strong, verifiable documentation of the need, we will ask you to vacate those units and rematch them to households that are sized appropriately. Questions from landlords, if any? I will add one thing here, which is that your annual reporting requirements, which is the subject of our next section, are mandatory, and they are mandatory whether or not city staff sends you a notice to recertify in a given year. I mention this because during COVID obviously disrupted city operations. The fire tragedy in January also affected city operations. So whether or not you get an invite from us to submit your annual reporting, it already exists in the deed restriction. The deed restriction is a legal document. So even if there were a layoff in housing and there were no more housing staff for this program, you or whoever originally signed the deed restriction, which you then accepted by purchasing the building or transferring property management to you, you are bound by it. So whether or not we send you that request, you have already signed the dotted line, or whatever agency has signed the dotted line to continue doing the annual reporting for the duration of the deed restriction. Which leads into this subject. The screenshot you see is our homepage for SantaMonicaHousing.org. If you do not have a login credential for this website, please contact city staff and we will work with you to get that set up. So when you log in, you should see this field on the left called cases. And if you click the little down arrow, a drop down appears. If you don't see this and you instead see something that looks like you are a waitlist applicant, like it's asking you for your personal household size and income, please let us know and we will make sure to reassign you to a landlord profile instead of as a housing applicant on the waitlist. You need to have a landlord account capabilities on SantaMonicaHousing.org. So step 1 is you click on cases with the dropdown, and step 2, once you get the dropdown, is you can go to Manage Manager Resources, and you'll see in the lower screenshot here that has all sorts of information in it. So we have a recertification user guide. That's the second link. You can click that for a PDF with tons of graphics on how to complete the recertification, which is what we're about to talk about for the next 50 minutes. We have a referral request guide on next to number 3. That's how to submit requests for units that are vacant from our city administered wait list. We have a template for the affordable housing lease addendum, which me and Jonathan have mentioned repeatedly. And we have the annual reporting income verification form for non-voucher holders, which I will also show you in a few slides with screenshots. So who needs to report? If you have any deed restricted unit, you need to report. If the unit's vacant, you need to report. If a voucher holder lives in the unit, you need to report. Reporting will look different for units that are vacant, units that have a voucher holder, and non-voucher households. It's a different process for each one, but no matter what, a report needs to be turned in for that unit. If you have 3 units on your property that are deed restricted, we need 3 reports every year, and they need to be complete and accurate. If you have 3 adults in a household, we need reporting information from each of those 3 adults. Adult is 18 plus, and it includes students. However, if you have, let's say, a 20-unit building and only 4 are deed restricted, please only submit 4 reports. Do not submit 20 reports. You do not need to report for units that are not deed restricted. In terms of going through the process we're about to talk about, which is about gathering income and asset information, calculations, working with the tenant, that only applies to non-voucher households. Tenants that currently receive voucher money to pay some or all the rent, you do not need to do this process with. You still need to turn something in online, but it will be a relatively fast and seamless process. Or that's what it ought to be. It's designed to be that way. Likewise, vacant units, obviously there is no one living in the unit. You do not need to gather income or asset information. So how do we do this? You go to you log in, it says signed in successfully at the top. You click on cases on the left. The drop-down appears and you're going to select manage occupancy reports. On the right side of the screen, you click the green button that says new occupancy report. This pops up. You select the reporting year. I think I actually have removed this section, but you would still select the building and the apartment number from the dropdown. If you do not see the correct apartment number, please contact us and we will work with you on that. The next mandatory field with a little asterisk next to it is whether the unit is vacant. You will select yes or no. If yes, you basically just scroll down to the end and there's going to be a little purple button on the lower right that says submit occupancy report, and you click that. Just make sure that you'll need to fill out all the fields that have an asterisk next to them. So at the bottom of the screen, there's a field that says I certify that information is complete or accurate. I certify the tenant is not earning more than the maximum allowable income for this unit, which of course, if the unit's vacant, there is no tenant, so you can go ahead and certify that. Just make sure you fill in the fields with the asterisk and you can click submit at the lower right. However, if the unit is not vacant, you instead click no. You're going to see these additional fields appear farther down. So you would type in the head of household first and last name, put in if they're a senior, yes or no from the dropdown. Select yes or no. Did the tenant move in within the last 12 months? If they did, please upload a copy of the lease. Select the correct number of occupants on this online submission report and select yes or no from the dropdown, indicating whether or not the household has a voucher and uses the voucher to pay some or all of their rent. Again, if the person living in the unit has a voucher, you do not need to complete an income recertification with them. The person with the voucher will actually do that with their housing authority staff member instead. I have an audience poll. If you could please type in the chat, how many of the 4 units below are required, will you be required to submit this type of annual report for? So there's 4 units in this building, 3 are deed restricted, the 4th is not. 1 is a voucher holder, 1 is vacant, 1 is a non-voucher holder, and 1 is not deed restricted. Please put the number of units, the number of reports like this that the property manager needs to complete and submit to housing every single year. Put that in the chat. And Renee, if you could give maybe 20 seconds and let me know what people are saying in the chat.
Sure. Okay, Nick, I have mostly 3 and a couple 2s.
The correct answer is 3. If the unit is vacant, you still need to submit a report. I'm going to go back to this slide right here. All you'll do is you'll select yes instead of no for the vacant question, and you still need to go down to the bottom and submit a report. The correct answer being 3. Thank you to everyone who took a look and put an answer in the chat. And if you have questions, please shout them out or put it in the chat and Renee will flag it for me.
And I don't know if folks were also confused about the voucher thing. I know you did just mention that very clearly, but to reiterate, vouchers, you don't need to do the income, you're collecting all the documents and all of that, but you do need to submit the report indicating that they have a voucher.
Thank you. I want to go through some housekeeping or administrative items for how this process for recertification works. Let's see. Annual reporting occurs through santamonicahousing.org. That is the only place where we will accept annual reports. We do not accept you completing a hard copy and mailing it to us. We do not accept them via email because as city employees, our emails auto-delete after 2 years. The only place that we will accept the reports is on santamonicahousing.org, which is why I mentioned earlier that if you do not already have login for santamonicahousing.org, please contact us. We will work with you to get that set up so you have landlord capability to complete and submit these reports online. Housing staff is currently sending out annual recertification notices in batches, so not everyone gets the same notification at the same time. Everyone here today got almost everyone here today got a fall 2025 notice on August 15th with a deadline of September 30th. So every building is assigned to either the spring or the fall batch. We track what percent of annual recertifications are received on time and at all. We then audit the reports we received for completion and accuracy. The audit is random, but if there are additional red flags, like we have people giving us tips or obvious things to look into like that, then we will also follow up proactively and review. Buildings that are not reporting that just are not submitting their required annual reports are not following their corresponding deed restrictions, and we may refer them to city attorney office for enforcement and follow-up. So this section here, like it says highlighted in bright red on the upper right, is for non-voucher households. If you have a voucher household, none of this applies. They do not have to fill out this questionnaire. But what you can see in this slide is what we call a tenant income certification form. It is 3 pages long, and every adult in the household fills out a separate copy of this form. So if there's 2 parents in their 50s and 1 adult child who's 19 who goes part-time to Santa Monica College, you need 3 copies of this form, and each one needs to be signed by each of the corresponding tenants and also by the landlord, as marked here in bright yellow, witness signature, landlord manager. The tenant needs to put their name in the top of the first page, and they need to select initial certification or recertification. If they're not sure, please help them or select it yourself as corresponds to the situation. And the tenant needs to select yes or no for each of these 30 questions. It's not acceptable for the tenant to leave 1 or more questions blank. They cannot select both yes and no to the same question. They must choose one or the other. If they are selecting yes and they're declaring some kind of income or asset, they need to explain it in the field to the right. So if, for example, they answer, I have a savings account in question 19, they need to check yes, the yes box. Then they need to list the bank. I have a savings account at First National Credit Union. The last 4 digits of the account are 5678, and my cash value is $500. Oh, I also have a savings account at Bank of America. The last 4 digits are 9012, and the cash value is another $500. They need to list all of their accounts so that we're not missing anything. This is the first step. The household fills this out. They're declaring what they have, and the landlord will then go through and review. The landlord should not sign at the bottom on page 3 until they are confident. They are basically verifying they have reviewed this with the tenant and they are confident the tenant has provided complete and accurate information. If that is not the case, like it says right here in bold on page 3, please flag it for housing team, and we are happy to be a resource. We will not do the recertification for you, but we will be a resource and try to work with you and troubleshoot if you're noticing red flags or discrepancies in what the tenants are declaring. So for example, a deed restricted unit has 1 adult. The property manager provides these 3 pages to the tenant, and there are several additional pages. There's one about whether the tenant has filed taxes or not for the year that are bright blue tenant. So you provide all the blue tenant marked pages to the tenant. You would ask them in writing to complete the required fields and provide supporting documents, give them 10 to 14 days to do so, and set that deadline before the city deadline. So For example, fall 2025 batch of recertifications is due September 30th. So you want to have the tenant materials to you probably by September 15th. So you have a bit of time to go back and forth as needed if the tenants have not turned in complete information or you need to get explanations from them on certain things. It is not acceptable for the tenant to just write their name at the top, leave these one or more fields blank, sign at the bottom, and turn that in. That is not a full recertification and is not a recertification that is full or accurate if they fill out this form and then do not provide supporting documents. So if they say, I have 2 bank accounts and I get income, and then they provide none of that supporting documentation, that is not complete. And you should not be submitting that recert when it's incomplete. What are supporting documents? We need these things from all adults in the household. So in the example I gave where it's 2 parents in their 50s and a 19-year-old at Santa Monica College, we need bank statements for all the accounts. The account for the first parent, the account for the second parent. Maybe there's multiple accounts for someone. We need all the bank statements from all the accounts. Well, not all the bank statements. We need like 3 months of bank statements consecutively, one after the other, for each account and each adult. Each person needs to give their most recent year's tax filing. So in this example, maybe the parents are married and they listed their 19-year-old as a dependent, in which case there is only one tax filing, but in each case, all 3 of them would still fill out a tax declaration stating whether or not they're required to file taxes. In other households, you might have 3 cousins. So in that case, they're not each other's dependents, probably. So they would each provide a separate copy of that individual person's tax filing. It's not acceptable to provide one person's bank statements when there's 2 more adults in the household. Provide one person's tax filing when the other 2 adults are not listed as their dependent, but do have to file taxes. Similarly for income, we need proof of income for all sources of income. Income includes money that people are getting on a recurring basis from their friends and family. The tenant will need to explain things like cash deposits, ATM deposits, counter deposits, Venmo, Zelle, PayPal. There's a couple additional ones I can't even think of off the top of my head, but they need to explain where's the money coming in from, where's the money coming into their account from. And it's your job as the property manager to take a 3-month average of those amounts and add that to household income unless they can give a very convincing reason why you shouldn't. Reasons you shouldn't, we'll get into this later, would maybe include something like an inheritance, an insurance settlement, a one-time, one-and-done payment. Cryptocurrency, we have a question on this page right here. Question 28, I own cryptocurrency, such as Coinbase or Robinhood. They must disclose if they have cryptocurrency, and if so, how much, and they need to provide statements for cryptocurrency. There may be some back and forth with the tenant about whether money coming in from friends and family is recurring contributions. The tenant may say, that's not a recurring contribution, that's they're repaying a loan to me. We will come back to that. Example, this one adult household was.
Sorry. There was a question in the chat that says, do we need to notate those explanations anywhere?
Yes, you should develop a form, like a table, even just in a Word document, that'll say name of tenant, date of transaction, account, like if the tenant has multiple bank accounts and the Zelle and Venmo is appearing on the Bank of America statement and not on their Capital One statement, you would say it's John Doe's account 1234. The transaction date is May 25th. The amount is $500, and the purpose and the source of the money is those $500 refund from Santa Monica College do not count as income. The next $1,000 was fill in the blank. It was Jane Doe did babysitting, John Doe did, dog walking, whatever. Going off of supporting documents, the landlord needs to obtain a complete signed tenant income certification form from each adult in the household. They need to obtain a copy of the tax filing and the 1040 declaration that's part of the recertification packet from each adult. They need to obtain a recent bank statement, actually 3 recent bank statements for all accounts. Proof of income, that could be pay stubs for some people, maybe a Social Security award letter, annuities, if they're working for Uber or Lyft, maybe an earnings statement. We could, for people who are self-employed, as gig workers, it could be a 2024 earnings statement showing how much they made in 2024. And then if they're continuing to work for the gig platform, they could show monthly statements showing the amount they pulled in a month of 2025 and take a rolling average, since we understand people's income may go up and down if they're working on gig platforms. If you have not already, this is an opportunity to sign the Affordable Housing Lease Addendum, which we have available on the city housing portal, as I showed you earlier. These all need to be part of it. These are all requirements for a complete file. Let's say there's 2 units, 2 adults in the unit. Each adult has one income source, 1 bank account. Again, not to belabor the point, we need 2 income certification forms. Both of them are complete, 1 per adult. We need 2 tax filing copies, unless they're married filing jointly. We need bank statements for each account, and the bank statements need to have all pages. The first page alone is insufficient and unacceptable. It cannot be redacted. The tenant may redact HIPAA-related information, so that we don't need or want to see HIPAA-protected information. Please do not show us that information is not meant for us. But on the other hand, if the tenant has basically blacked out the entire statement, except where at the top it says, you know, Merrill Lynch, that also is unacceptable. So they need to be, for the most part, unredacted, except for maybe HIPAA compliant information. Proof of income, we need it for each adult, not just one of the 2 adults. And each adult needs to sign the Affordable Lease Addendum, Affordable Housing Lease Addendum. Landlords, it is your responsibility, not just ours, to review for completeness and accuracy. My role as housing staff is to audit. Your role is to make sure that the material is complete and accurate before you sign and before you submit. As needed, you need to request additional documents or corrections from the tenant. If the tenant is continuing to provide inaccurate, incomplete, or misleading information, please flag it for us. And like Jonathan mentioned earlier, as long as they've signed that Affordable Housing Lease Addendum, the tenant is actually committing a violation of their lease, which requires them to provide complete and accurate information to you. And that, you know, it's your job to proactively ensure compliance with the lease terms, the Affordable Housing Lease Addendum, and the deed restriction requirements. But we are available as a resource that cannot and will not provide legal advice to troubleshoot as needed. As one example, we have this 1-person household. They have provided a bank account. They've declared it on the declaration form, and they've also provided complete statements. They've also provided 1 source of income with the pay stubs. However, the landlord reviews the bank statement and sees counter cash ATM deposits in addition to the direct deposit pay stubs. What should the landlord do? Ask the tenant questions. Something here doesn't add up. 1 + 1 = 3 this time. It needs to equal 2. So the landlord should say, "Dear John Doe, thank you for providing your pay stubs. Thank you for providing your bank statement. Please explain the cash deposits that appear repeatedly on your bank statement. You have X amount of time to do so. You've signed the Affordable Housing Lease Addendum guaranteeing you will provide complete and accurate information. So if you do not, you know, that is an expectation of our interaction here." You would say something like that to the tenant, give them a reasonable amount of time to respond. And if they do not respond, you enforce the Affordable Housing Lease Addendum and enforce your deed restriction requirement. The next step, once you are comfortable with the information the tenant has provided and you believe it is complete and accurate, is you as a property manager need to fill out the pages and the signature lines that are highlighted in bright yellow marked for a property manager. So here's a screenshot of those 3 pages. Like I mentioned earlier, some of the fields on the first page in the left will require you to go to the deed restriction and to our city website showing maximum income and rent levels to calculate the unit's affordability level, maximum allowable rent, and then down here, maximum allowable income. You only need to complete one of these two items. Oh, this is fine. Highlighted in red at the bottom. If they're a new resident, you can just you can put in the new resident amount. If they're a continuing resident, you multiply it by 1.4. But these are the fields where you will need to go back to that process I outlined earlier. If the household has more than $5,000 in assets combined, you need to add that to household income. So let's say it's 2 adults. The first one has $3,000 in assets. That could be cryptocurrency, and the second person has $3,000 more dollars in assets. And for them, those $3,000 are in their savings account. Combined, they have $6,000 in assets. You need to take 10% or $600, and you're adding that to the household income. This is the common thing I see landlords not do. You need to get complete information from them. If you look at the bank statements and you see that the tenant is transferring money to themselves from an additional account they have not reported, you need to get the statements from that account. If you're seeing the tenant is moving money to and from cryptocurrency accounts, and it says minus $5,000 to Coinbase, plus $3,000 from Ethereum, you need to get those assets before you calculate household income, because if you calculate household income inaccurately and it's very obvious you didn't obtain complete information, you are putting yourself and your deed restriction compliance in jeopardy. If the tenant on the declaration says, yes, I have a job, I make $20,000 a year, and then you look at the pay stubs and the tenant, which you need to, and the tenant pay stubs show that they have made $40,000 already and it's only June, then please ask the tenant to correct the amount on the tenant declaration form and use the amount on pay stubs. You never want to use the amount. The tenant is self-reporting in the supporting documents to the extent possible. There may be a case where, for example, even if the tenant is saying, I declared that my family members give me $1,000 a month, it's your job to go through the bank statement and see how are they paying you? Are they paying you on the bank statement here? You said they paid you $1,000 a month, but I don't see any transfers to you on your bank statements. So it's your job to go through and make sure this all lines up. And if you look at the bank statement, it says from cousin X, $3,000, and then the average for those 3 months of bank statements was in fact $3,000, not $1,000. You used the amount on the bank statement, the third-party deposit. You don't use the amount the tenant self-declared or the family member friend self-declared. The fourth point here is about businesses tenants own. Tenants have to report information about businesses they have an ownership stake in. That's one of the questions here on the form. Let me just show you. Questions 30A and 30B are about whether the tenant owns their own businesses or has an ownership stake in one or more. So the tenant needs to declare that on the form. If you are seeing that there are indications the tenant owns their own business, they need to declare the assets that the business has. If the business owns property, it owns an office building, it owns one or more real estate properties, it generates rental income, the tenant has 50% ownership and gets 50% of the money generated from something owned by 2 other people, whatever, that all needs to be factored into how you're calculating the household income in this section. And if you're not sure because it's confusing or the tenant seems to be moving around assets, or things can get complicated if you're reviewing their tax filings, you are welcome to reach out to us and we will do our best to take a look and apply a second pair of eyes. And
one nuance that is not going to happen very often is that the income calculation is the greater of the actual income from assets, or 10% of the total value of the assets. So if you're talking about a whole bunch of money in, say, a high yield savings account, that's, it's still going to be pretty easy. It's going to be 10% of the value of the assets. There's a theoretical possibility that, say, a property is being rented, at an annual amount that's actually more than 10% of the value of the property, for example. And so it's not necessarily something I want you to worry about, but you will see that in that income calculation worksheet. That's that note with the asterisk on that section 2. And certainly that's one of the things, if you have a question there, you can reach out to the housing division.
Any questions before I continue? Exempt types of income. Again, the focus here is on one-time events, a one-time inheritance. Jane Doe gets $1 million from a relative. We don't count the $1 million towards her income. However, let's say that she spends $100,000 to pay off her credit cards or her car note or all of the above and her student loans and also whatever. She spends 100,000, she has 900 left, and the 900 is now in her bank account. You do not count the $1 million towards her income. You would take 10% of the remaining $900,000 since they're in an account she has access to, 90,000, and you add that to the household income. A one-time insurance settlement, same deal. You do not count that as income, but if the money remains in the account, that's just part of the 10% you calculate once it exceeds $5,000 for the household. Lottery winnings, same thing. Scholarships. When you are dealing with tenants who are full-time students, please request that they provide you with a statement from the college. These should be downloadable from the college website, and it will say John or Jane Doe is enrolled as a full-time student, X number of credits. And then if you see that they're getting like refund payments from the college or university system, the amount that is covering class, lab fee, health insurance fee, mandatory fees, that does not count as income. However, if they get money that goes above and beyond basically mandatory expenses, that will count as income. So for example, the tenant is working part-time. You would count the part-time employment, even though it's for the university, as income. Exempt retirement accounts, unless they are withdrawing money from the retirement account, in which case you do count it. I saw a case recently where the tenant claims she was withdrawing money from the retirement account, but she promises she won't be doing that again. It was just, that's it, that's done, that's fine. But for this go around in 2025, she was withdrawing money, so you do need to count it as a covered entity that counts towards that 10% of assets over $5,000. Next year, we can take a look at her account and see if she is still withdrawing money or not. If not, no need to get the to add that value to the household income calculations. You do not need to get into interactions with tenants over $10, $20, $25 Zelle and Venmo payments, unless you see that there's like $400 or $500 worth of Zelle Venmo payments from the same one person, or if you see a pattern and you can tell it's a lot more money than that, then obviously you follow up. But if it's just like these small little ones, obviously that's not the most constructive way to use your time. So we're really looking for amounts that are above $100 a month, or maybe a few $100s a year, and those would count as recurring income. Lastly, if the household has a minor under 18 and they are working part-time or doing odd jobs, that does not count towards household income. Conversely, we have adult household members who describe their cash deposits in their account as repaid loans, or I received a loan from my family member. My family member got money from me, now they're repaying me. Those do count as income, unless the person who's giving / receiving the money notarized the loan at the time they took it out. So if they went to a notary and they said, I'm cousin so-and-so, I'm taking out or giving money to the tenant, here's, please sign, and they have the notarized, then fine, we will not count that towards household income. But unless there's that notarized signature at the time the loan was taken out, if the notary gets involved later, I'm sorry, that does not work, and we will count loans and low repayment towards household income. Likewise, if it's a gift that reoccurs month after month, you need to count that as household income. It's not acceptable for the tenant to say, you ask the tenant, why do you have $1,000 coming into your bank account every month from so-and-so? And the tenant says, well, in January, it was my New Year's present. In December, it was my Christmas present. In November, it was my Thanksgiving present for Black Friday. That means it's not a gift. I mean, it's not a one-time gift, it's a recurring gift. So they need to fill out the family friend support statement, and they need to amend their personal declaration form and make sure they're checking, yes, I do get recurring payments from someone who doesn't live in the household. And then you would take the 3-month average of those amounts as appears on their bank statements, and you would add that to household income. Do we have questions on that? So the next question is about people who are over income. So let's say you're recertifying a household and they turn out to be earning more than the maximum established under the deed restriction for that household. So here we get into more specific conversations about what types of circumstances are going on. So situation 1, the landlord never told the tenant is over income. They now make $200,000 or $300,000 a year, But the landlord never told the tenant that there was an income limit attached to this unit. Who's in the wrong? The landlord or the tenant? The landlord's in the wrong. The landlord was supposed to be enforcing this program from the day the tenant moved in. The landlord was supposed to be following the deed restriction this whole time. Instead, the landlord has now kind of turned around at some point after the tenant moved in years ago and suddenly decided it's time to enforce the deed restriction, probably because of a complaint against the landlord. And it's actually the landlord is the one at risk here, not the tenant. The tenant may be in an uncomfortable situation, but the tenant, it's hard to say the tenant's over, I mean, the tenant's over income for the deed restriction, but because the tenant did not know, the tenant cannot be punished. The landlord cannot be threatening the tenant with certain things that the tenant, because the tenant's income is too high. The tenant was never informed of that up until now. The second circumstance, leasing to an over income tenant. So this is the case where the deed restrictions, let's say the deed restriction said the household cannot earn more than 100,000 this year. The landlord goes ahead and offers the deed restricted unit to a tenant household making 120,000 a year. Maybe the landlord did not collect the full documents required. The landlord just decided that the deed restriction was inconvenient, or it could have been lack of record keeping. But at any rate, the consequence for the landlord is the landlord may be responsible for relocating the tenant. So the landlord will need to issue a notice to vacate to the tenant, presuming the landlord informed the tenant that they are moving into a deed restricted unit. They will need to issue a notice to vacate, and they may be responsible for relocation fee. So a relocation would be storage, moving cost, and utility connection fee. In the third circumstance, continuing tenant is over income. This is somebody who qualified at moved in. At move-in, the tenant could not have earned more than 100,000 and the tenant earned 90,000. So they were fine at move-in. They were not the owner. They were not the property manager. They're not the owner's child. They have been recertifying. They've made a good faith effort to follow the rules. They have not been using their unit as an Airbnb. They have not been using their unit 2 months of the year and living other places 10 months of the year. The only thing is that as time has gone on, the tenant household income has now risen above the maximum for the unit. The tenant gets a 12-month notice to vacate. Provided again that you have an affordable housing lease addendum and they were aware they're in a deed restricted unit. And lastly, the tenant is over income and is violating the lease. They may be having an unauthorized subletter. They may be doing Airbnb. They may be refusing to complete their recertification after you ask them to, but they already signed the affordable housing lease addendum. In that case, you would give them a shorter notice than a year. And you can reach out to us if you're in this circumstance, and we will not provide legal advice, but we will troubleshoot with you to make sure that we understand the nature of the situation as clearly as we can, so that if and when the tenant gets a notice to vacate and they come over to us and they say, what is this? We have been informed beforehand, hopefully, of what's going on here and your attempts to bring the unit and the building into deed restriction compliance, and we can get the problem resolved promptly and appropriately as possible. So all of the above has now occurred. You have correctly calculated the household income based on all these tips. You filled out the pages marked as property management. You have even signed the landlord signature lines under the tenant pages, such as the tenant income certification questionnaire. You have materials from the tenants, each adult in the household, not just one adult. It is now time for you to finish the online certification process. So does the household income exceed the maximum allowable income? Most cases it will be no, it could be yes in some, in which case please refer to what we just talked about. You're going to certify, is this unit in compliance with the deed restriction? If it's not, because the tenant's earning too much income, that's on the tenant. You have just enforced it as the property manager. You have given them a 12-month notice. You can go ahead and click yes. You select your relationship. Who are you? You're an agent of the owner. You type in your name and your date. Scroll all the way to the bottom. You need to click upload income evidence documents. So this is where you attach one or more attachments, and these will be versions of these pages the landlord filled out, as well as the tenants pages, as well as the supporting documents. These are things like the tax filing and bank statements. You need to attach all of those as attachments. Then you click the submit button, create occupancy report in the lower right. We want one occupancy report per deed restricted unit per year. Please do not create multiple reports per year. Please do not create one occupancy report per adult in the household per year. It is one occupancy report per household combined with all of the adults, one per unit per year. Moving on, my question to property managers is if you have recently become involved in dealing with us, dealing with Santa Monica below market housing program and deed restrictions, would a separate event for new property managers like an orientation be valuable? And if so, covering what topics? And feel free to shout that out, or you can type it in the chat and Renee or Brittany will flag it for me. Brittany is my coworker here at the below market housing program. And yeah, so please go ahead and put that in the chat and we will take note of that. Do we have any general questions about material we've covered today?
Hey, Nick, I guess I have a follow-up question on the Airbnb situations. So we were successfully before we were able to get a couple of Airbnb out of our properties. However, I do have suspicious of a unit or 2 units that they are maybe doing Airbnb because neighbors are complaining but sometimes neighbors can be over dramatic or they're not saying the truth. I have talked to the tenants before, hey, this is not supposed to happen and you have signed a lease. And he or she keep denying, oh no, we are not Airbnb, we're not. And I cannot prove anything. What should I do next if I do have in my gut suspicious that they are 100% Airbnb?
If you're that confident, send an email to me and let me know what unit, and I'll take a look through their recertifications as well and see if there's any red flags like bank accounts they failed to report.
Okay, sounds good.
We also may be able to have certain investigatory tools, but you should let us know.
Cool. Right. I guess I will email you guys, Nick and Jonathan, later today or tomorrow. Thank you.
Yeah, thank you.
There's a question in the chat. Will you be sharing this slideshow for us in the link?
What we'll do is I will post a recording of this on YouTube, so you will be able to see the full event series on YouTube. If you want a copy of the PowerPoint, if you put your emails in the chat, I can send it out to you BCC this afternoon. Any other questions? I will stop sharing, but thank you for making yourselves available today and familiarizing yourself with the program and its processes. You have my contact information because you received this invitation and email. If you don't, you are welcome to send further questions to the group chat and Teams. And I thank you again for your time and participation today. So take care.